Hello everyone, welcome to GST Town Hall on and Case Law Alert. One of the laudable judgment coming from Honorable Gujarat High Court on Rule 96 Sub Rule 10 of CGST rules. That is what we will be discussing today. As per this rule, IGST refund is not permissible when exporter is availing the benefit of deemed export scheme or export promotion scheme. For example, against an advance authorization EPCG or 100% EOU. So what happens? So what happens is these units, when procuring import of goods, they get the benefit of exemption and they don't pay any IGST and compensation cess. They avail the benefit of exemption on procurement of goods. Thereby, there is a restriction imposed that they can't export on payment of IGST. Rationale was simultaneous benefit that on one hand you're availing exemption towards payment of IGST and compensation cess on import of goods. On the other hand, if you're being allowed IGST route for your export, then you're doubly benefited. Of course, they can export under LUT or bond. So this was the restriction under Rule 96, Sub Rule 10 of CGST Rules 2017. This was challenged before Honorable Gujarat High Court. First, why the constitutional validity of this rule, 96 Sub Rule 10, was challenged before the court. And this rule was also debated in trade, and trade has represented the subject matter to GST Council as well. And that's why this restriction is being imposed. There may be a situation that they are paying IGST from their pocket on exports, which should be tax-free. They must be refunded back. Keeping this in their mind, they have challenged this Rule 96, Rule 10 before Honorable Gujarat High Court. What is the judgment which has come from Honorable Gujarat High Court? So they have seen that GST Council has recommended omission of this particular rule. On this recommendation, by notification number 20 of 2024 Central Tax dated 8th October 2024, this rule got omitted. It was prospective. The date of notification making this omission effective from 8th October 2024. So the question before the Honorable Bench was whether this omission can be applied retrospectively. Because being clarificatory and demand of trade was they must be getting IGST refund even in these specific situations. Second, whether this rule is prospectively applicable. Third, is this going to be applicable for only pending cases which is pending before adjudicating authority? Those who have come and filed the writ petition which is yet to be adjudicated, maybe show cause notice level or order which is supposed to be appealed but did not appeal, writ petition was filed, so that it is not getting any kind of adjudication done by the respondent revenue department. But they have gone and filed writ petition before the Honorable Gujarat High Court. Whether they are also getting this benefit, let's listen to the judgment. What it's talking about. It's a laudable judgment. Now, this judgment is saying you are entitled as a taxpayer. For IGST refund, you will get refund of IGST when you have exported on IGST, even though if it is under these specified schemes. For all pending proceedings and cases. What could be pending proceedings and cases, which is either pending before adjudicating authority or pending before appellate authority, or you are the petitioner, you have filed the petition before Honorable Gujarat High Court, and your subject matter was pending before the Honorable Court. So this judgment is saying that this is applicable for all pending proceedings and cases, and because of this rule got omitted effectively from October 8th, 2024. So anything which is pending as proceedings and what could be proceedings that can be considered. Either it is pending before revenue officer for adjudication or appellate authority or pending before court because it is yet to get the finality. finality has to be arrived at. So, pending proceedings and cases as on 8th October 2024 are entitled for IGST refund. That is what it is being stated. But on the questions of bias of this particular rule and constitutional validity, the Honorable High Court has not decided on the bias or constitutional validity of this particular rule and has got further omitted also. So, while discussing repealing or omission part, because there was no saving clause, so they have considered section 6, 6A and section 24 of General Clauses Act while comparing with the repeal or omission provisions. So benefit is given to all. It's a laudable one. So you are entitled for IGST refund on exports. In case it is being disputed and your dispute is pending either before adjudicating authority or before appellate authority, or your subject matter was pending before Honorable Gujarat High Court, this is the judgment of Honorable High Court. Such type of cases are pending in other high courts as well. Of course, when you look at the jurisdictional reach of Gujarat High Court, the High Court, it's applicable only to state of Gujarat. But on the question of law, because bias is not being decided, we have to keep a watch as to what kind of judgment we are getting from other high courts. And quite obvious, we have to see whether revenue will accept this judgment, that is, government will consider filing an SLP before Honorable Apex Court. But all in all, it's a laudable judgment. A lot of taxpayers will get the relief. So that's the update for now. Thanks for watching. Stay tuned for more such updates and keep attending the town halls. Thank you very much.